Can we move up? There we go. Okay, we got it. Okay, there's the slides. We can move to the first slide. Okay, so as mentioned, my name is Mary Tovella Dowling. I am a partner with For Purpose Law Group. We are a law firm that is based in Southern California, though we represent nonprofits, tax-exempt organizations, and social enterprises throughout all of California, as well as Arizona and Washington, D.C. We specialize in the representation of tax-exempt organizations from anything from formation to dissolution and everything in between. So whether it be advising on governance, on public support tests, tax matters, or litigation matters, we serve as outside general counsel to navigate some of the uncertain landscapes when it comes to the legal needs as they pertain specifically to tax-exempt organizations. Today, I was asked to discuss about building resilience and sustainability from the legal perspective, specifically within the nonprofit sector. Now, more than ever, we're responding to uncertain times. So we'll go through, some of, the changing landscapes as, some of these challenges that has been faced by the sector, how we can respond and how we can become sustainable through these times. Next slide, please. So a bit of a roadmap for the next hour while we're together and what we'll be talking about. First, what are the changes to the current legal landscape? I'll state the obvious here. Obviously, we have the pandemic, but we'll talk about some of the tax changes specifically that have come into play with regard to the CARES Act, as well as the TCJA, the Tax Cuts and Jobs Act. In addition, we'll talk about understanding the implications of these legal landscape changes. How do they affect the sector? How will they affect your organization specifically, and how we can respond to them, as well as talking about discussing and analyzing non-traditional funding and revenue models so that we can create a sustainable sector. Next slide, please. Okay, so let's talk about the first. Although we are definitely in a time of uncertain changes and we're trying to adapt to things happening in our world, it's not so foreign to us in that we've had many changes to the sector spanning back to 2018. So the sector was first faced with adversity and having to respond or adapt in response to the Tax Cut and Jobs Act. So on December 22nd, 2017, President Donald Trump signed the Tax Cuts and Jobs Act into law. This act represents the most comprehensive overhaul of the U.S. tax code in over 30 years and took effect on January 1st, 2018. Next slide, please. So there's many significant effects of TCJA, or the Tax Cuts and Jobs Act, that pertain specifically to nonprofits. And we'll talk about a couple of those and how they've forced the sector to adapt and change, and how it's really it's really shook things up, specifically with regard to a donor pool and funding methods for nonprofits. So the first is a reduction in the number of benefiting taxpayers. So the act essentially doubled the standard deduction. So for 2019, the standard deduction was $12,200 for single or individual taxpayers and $24,400 for married filing jointly taxpayers. So at the same time, the act eliminated or curtailed many valuable itemized deductions. So IRS data shows that the number of taxpayers who itemized their personal deductions and claimed a deduction for charitable contributions for 2018 declined by about 20 million over the prior year. So that's really significant. And so as a result, taxpayers itemized 54 billion less in charitable contributions compared to the prior year. This had a really negative impact on giving. So one of the most substantial changes was that the percentage of taxpayers who itemize their deductions went from around 35% to 6%. And so this was the largest decline since 2008 financial crisis. So what we're seeing from a sector standpoint is there's less donor dollars out there because there's less of an incentive to give. So we're seeing nonprofits relying less or being forced to rely less on the traditional donation methods, contributions, grants, donations from individual philanthropists, and think about other revenue models like earned revenue, joint ventures. In addition, the act also had an effect on the number of bequests. So there's fewer charitable bequests as a result of these tax changes. So some of those stats: in 2019, estates worth up to $11.4 million per person, or $22.8 million per married couple, and for 2020 up to $11.58 for individuals, are exempt from federal estate tax, more than doubling the amount that it was in 2017 prior to the enactment of the act. So one of the main reasons wealthy individuals make charitable bequests in their wills is to help avoid estate taxes. Charitable bequests are not subject to this tax. With fewer taxpayers subject to the estate tax, there's much less of an incentive to make charitable bequests. And as a result, the number of bequests have significantly declined. So again, what we're seeing is a stark reduction in donor dollars, forcing nonprofits to rely less on individual philanthropy and philanthropists to fund their missions. Some other changes that had significant on the back end that organizations are seeing in the amount of tax that they're paying when it comes to unrelated business income tax. So as you know, just a threshold issue, UBIT or UBI or UBTI, you might have heard or referred to it as, is unrelated business income tax. What that means is, traditionally nonprofits are exempt from paying corporate income tax, but that's only with regard to income that is derived from an exempt purpose or, exempt earned revenue. When an organization engages in an unrelated trade or business, whether it's because it's unrelated to their exempt purpose or it's commercial in nature, there may be a rationale for them doing it. They're still creating a profitability there that can fund their mission, but it's subject to tax, to even the playing field between nonprofits and for-profits. So they're still paying a tax. Now, under the act, under the prior law, a nonprofit that operated multiple unrelated trades or businesses could deduct the losses from one business, from the profit of that business, from another, to determine the amount of net unrelated business income subject to UBIT. Now, this was very, very beneficial because you may have one line of business that has a lot of expenditures or expenses, and you can offset one against the other, essentially having your cake and eat it too. So the act no longer allows you to do this. So starting in 2018, each unrelated business must determine its net income without regard to losses from the other unrelated trade or business. So as a result, it's likely that more nonprofits will be required to pay UBIT. And so many nonprofits are attempting to get rid of the money-losing businesses that they were previously operating. There were other significant changes, such as the excise taxes assessed on the net investment income of certain colleges and universities. So at least 500 students, it was applicable if you had at least 500 students and $500,000 in endowment per student. There was a 1.4% excise tax on the investment income, and also changes that were affected. There was new excise taxes on compensation in excess of $1 million. So there's many of these changes that nonprofits are having to navigate. They still are, even though they were enacted in 2018. We're just recently seeing the effects of them because we've really only, with the 2019 tax period we're currently in the process of preparing those returns and seeing the true effect of that, and seeing what types of reduction in income we're having and what type of increase in expenditures we're having as a result. So with the tax period and the filing deadline, if you were on a calendar year being May 15th, many times those nonprofits that have increased revenues over 2 million, we have that extension to November. So we're still not seeing a full picture of the impact that the act has had on the sector. And we're continuously working to adapt to see how we can utilize this new tax code to adapt to it. Next slide, please. So I have a bit of 2 slides here that I have out of order, but we'll go into another unexpected change in the legal landscape, which is again stating the obvious, the pandemic. So it's not a huge tax code change, but it's an external change that is having an effect on all businesses, all individuals on a personal level, as well as on a corporate level, which is of course COVID-19 and the pandemic. So what are we seeing? And again, this isn't necessarily specific to just nonprofits, but nonprofits are absolutely feeling it. And arguably what I have seen is, although there is, effects on the obvious effects on the economy, this is the segment of the population, nonprofits, that, it's time for you to step up, right? Our society and our communities are in crisis. And this is why nonprofits exist, right? So really, this is an opportunity for us to walk the walk and not just talk the talk. Communities need nonprofits now more than ever. And so it's critical, even more than, other businesses, other individuals, for nonprofits to step up and to help us get through this hard time. So what are some of the effects of the pandemic? Well, that's very unique depending on the organization, but some of them, challenges with staff and volunteer availability. With many shutdowns and many shelters in place, our ordinary operations aren't as feasible as they used to be. We're having less staff and less volunteers able to come and help out, whether it be because they're affected by COVID-19 individually, whether it's because they don't have access to the technology needed to carry out changes in programmatic activities. We're being forced to rally together and find a way to carry out these necessary programs and further our mission with less staff and less individuals to help us do it. Inability to provide essential services. There are some limitations that are set by a state level, federal level, local levels that are prohibiting all businesses from opening their doors to the general public, from operating their business. And there's a difference in what is deemed essential. So that's very, very locale specific and state specific as to what is deemed essential and what can and can't we do as a business and as a nonprofit in light of laws and regulations that are changing on a monthly basis. Changes in public demand. That's a big one, right? So programs that used to have a very high demand that may affect your organization, we could see a complete drop in that demand. Youth sports-based organizations had, a very, very hard hit in the beginning of this, and that we couldn't have large groups come together. So we're having to see, this type of demand is no longer there. Is this going to be a temporary drop in demand? How can we adapt to that? Canceled revenue generating programs. So again, because of these regulations that are changing, are we having to cancel those revenue generating programs? Are we having to create alternative ones? Let me answer. I see a question popped up here. And again, feel free to chime in, so we're not listening to just me talk the entire time. Regarding itemized deductions and donations, how can taxpayers plan to donate every other year as a way to push their itemized deduction amount above the standard deduction? So It's a good question, though it's a very individualized answer to an individual taxpayer and what their financial plan looks like. We'll get to it later in the slides, but there definitely is a way that nonprofits can utilize changes in law, such as the CARES Act, to at least for 2020, and that may extend, to utilize these changes and to say, hey, it might make sense for you to itemize. So the standard deduction amount has increased to 100% if they donate to a 501c3 public charity. So for individuals that have the capacity to give, it may make sense for them this year to donate, because essentially if they were going to be paying tax to the IRS anyways, they can essentially have a zero adjusted net income and give to a charity instead of the IRS. We'll get more into that though in the next slide. So going back to other, sorry, one back. Thank you. Okay, reduced government, private, and earned revenue funding. This we haven't completely seen yet, right? So currently the CARES Act, and like I said, we'll talk about that in the next slides that come up. But the CARES Act offered quite a bit of measures and cash relief and economic support to businesses, including nonprofits, to certain tax exempt organizations. So it's not that we necessarily have seen reduced funding from a government standpoint yet, but other private foundations and individual donors and grant makers, they're also clamoring, are we still going to have the resources? And there may be a hesitancy to give or to commit less than what they were prior, because there's so much unknown. So we're having to, alter and shift to say, what can we do to plan if there is that reduction in grant funding? Other effects of the pandemic, increased employment law liability exposures. So this is not necessarily new to nonprofits. What I see in my practice quite a bit, I think the number one calls that I'm getting now and advising on to my clients are employment related laws. And many nonprofits rely heavily on volunteers. And there's a misconception that, the employment laws and regulations don't always apply to nonprofits, which isn't true, right? We are in a state that has laws that very heavily protect employees for good reason. And it's important that nonprofits take that seriously. And ignorance of the law is not an excuse, right? And so it's already tough to comply with employment laws and regulations as a nonprofit when maybe you have restricted resources to be informed or have that arsenal or understanding of employment risk mitigation measures. But especially in light of COVID, there's even more of a reason why we need to make sure that we're mitigating our risks. The stakes are much higher, and there's a much higher likelihood of employment law liability exposures. And then lastly, we'll talk about during this session just some increased general liability exposures, from just a general legal perspective, whether that's, breach of contract, canceling meetings, canceling conferences, canceling fundraising events, things that, kind of adapting and changing to online platforms. What additional slew of legal considerations shall we be thinking about if we're, changing our programmatic activities to adapt? Okay, next slide. And as I mentioned, I had a bit of a snafu, and these two slides were back to back so we can push forward. But this is essentially, another change in the legal landscape, the 2020 pandemic affecting individuals and businesses worldwide. And there's significantly and possibly permanent effects on these different sectors, which we just talked about. Next slide, please. Okay. So thinking about these external changes in the legal landscape, whether it be ones that we had a bit of time to plan for, like tax code changes, or ones that were completely unexpected, that we're really in a response mode, we need to think about the concurrent needs. And although, right now we're just responding, trying to keep our heads above water, it's changing every day. We need to think about, let's look in the future a bit and think about response, recovery, and resilience, and how we can balance all of those needs, and think about how we can come out stronger. And at the end of this, be more sustainable. So in the event that there is another external crisis that the sector is faced with responding to, it can do so stronger and more confidently. So in response, what is necessary to address the crisis as it manifests for our organization? What resources do we need to survive? Is that financial resources? Are those legal resources? Is this manpower, technological resources? Are these needs different than the needs of other organizations, right? So now more than ever, as a sector and a community, reaching out to other organizations, they're in the same boat, right? Not having this competitive spirit, but rallying together to say, what types of resources can we join together to have less of that overhead to make it through this time? Or is there a way that we can consolidate our needs to better help both of the organizations or all of these organizations push through? And how can we leverage the sector to respond immediately with the least amount of impact? So concurrently, we're thinking about recovery. I mean, arguably, we're still very, very, very much in response mode, but we'll soon be entering into that, hopefully, optimistically, be entering in or eventually into that recovery mode. So what will it mean for our organization to operate immediately after the crisis and a new reality? And this isn't pertaining, again, just to the pandemic, although that's on the forefront right now, but to any change, external change that the sector has to adapt to. When we're in that recovery phase, is it going to be a new reality? Is it a permanent change that we're going to have to adapt to and implement and continue these programs? Or is it something that, was temporary and now we have to revert back, adapt to another change to go back to how things were before? What changes do we need to make in order to operate in this new reality? And how do we return to a set point? And then finally, resilience. Out of this, if we've made it through the crisis, if we've made it through the change that we were forced to adapt to, if we made it to the other end, how can we prepare for the next time a crisis inevitably hits? How do we build long-term resilience strategies? And what should be in our legal arsenal for risk mitigation? We'll talk about that. Next slide, please. Okay, so as a preliminary from a very, very high level view, how can the sector react? We may be forced to let go of traditional fundraising methods. So many nonprofits rely very heavily on contributions, grants, donations. So from a general standpoint, when we're talking about tax-exempt organizations, we have a nonprofit, and then your exemption is based on the programmatic activities that you operate. Most commonly, we have 501c3s. When we're talking about 501c3s, there's two types. There's a private foundation and there's a public charity. The main difference between these two types of entities is how they're funded, what revenue streams are coming into the organization. So with a private foundation, we have most of the revenue coming in from a single donor or a single revenue source, a single company, a single family. Whereas a public charity, it's funded and supported by the general public at large. Now, there's different ways that we can meet the public support test. Most commonly, we think of 501c3 public charities being supported by contributions, grants, and donations. Now, when we're thinking about these changes in the tax code and the reduction of donor dollars, or impacts to the economy, and so there may be less of an incentive or a capacity to give from individual donors or corporate donors. We need to think about non-traditional revenue streams. Maybe that's offering a service or a product, and not relying only heavily on contributions, grants, donations. If doing that, we need to think about, will this affect our public support test and how we're classified and what formula we assert to the IRS on an annual basis to prove that we are in fact a public charity. Now that's important because the deductibility limits for donors are different depending upon whether they're giving to a private foundation or a public charity. So we want to make sure that if we are no longer meeting the public support test because we were formally classified under one formula, if we're changing that, if we're changing significantly how money is coming in, we're no longer relying a majority of contributions, grants, donations, but more primarily on earned revenue from a fee for service, then we may not be meeting our public support test, and we may need to do something such as a miscellaneous determination to change with the IRS how we're classified, so we can protect and not jeopardize that public charity status. Diversifying our funding methods. So again, it should be noted that it's not that an organization has to only pick one formula. They can only rely on donations, contributions, and grants. You can have a combination of both. You can have revenue streams from earned revenue. You can have contributions. You can have government grants. You can have individual donors giving and philanthropy coming in. You should diversify and have more than one revenue stream coming in. It's important that when we're reacting to these changes, we're understanding the legal implications and proper structuring of these creative funding and revenue streams. So if we're changing how the money is coming in, we're not being ignorant to the additional legal obstacles that those may present. Maybe it makes sense for an organization to engage in an unrelated trade or business. Sure, we're paying tax on it, but it's still bringing in money to the organization, right? So what other additional legal or tax considerations do we need to have if we decide to pursue that additional revenue stream, right? How much tax are we going to pay? Are we going to have a profit on it, or are expenditures high enough that it really justifies we're not going to have much of a tax liability at the end of the year? How much UBIT, if we're going to have to pay unrelated business income tax, is that going to create? The IRS, again, acknowledges and accepts that nonprofits can engage in an unrelated trade or business so long as it's not a substantial amount, right? So your next question is probably, well, Mary, how much is too much? And there's no black and white answer to that. It's a facts and circumstances test. And you'll get a different answer from different practitioners depending on, the organization's risk threshold. Some will say no more than 10%. Some will say less than 50%. So really it depends. It's a holistic analysis of, what is the activity that we're engaging in, and how much tax is that in relation to or how much income is that in relation to your overall income and revenue sources that are coming in. And then again, just creative restructuring of existing programs. Many organizations, though they may be prohibited from carrying out their programs, the purpose of that program and the need that it served is probably still there. And it really offered a huge benefit. It's finding a creative restructure of how that program is delivered and how that need is met. Okay, there's another question here. On diversifying the funding methods, when do you think it is appropriate for nonprofits to take a leap into social enterprising? It's a really good question. So when we talk about social enterprises and social enterprise, we're in the era of, it's a rise of social enterprise. It means many different things to different individuals. When we talk about a social enterprise, it may be partnering with another for-profit that has a social enterprise structure. In California, there's different social enterprises. There's a benefit corporation and there's a social purpose corporation. There's also a limited low profit liability company. So those are companies where it is a traditional for-profit from a legal and tax standpoint. But it's a for-profit with a bit of nonprofit DNA, right? So not only does the social enterprise doesn't have to operate solely to maximize shareholder value. It can take into consideration some social purpose when carrying out its activities. So for nonprofits, many times when it wants to engage in an unrelated trade or business, but the purpose of that trade or business, it's commercial in nature, they would have to pay tax on it. It's not an exempt revenue, but it's still the purpose for why they're doing it is not to, line the shareholders' pockets with dollars. It's to serve a social need or to answer or solve a social problem. That's when a social enterprise makes sense, right? So it may make sense to talk about joint ventures, this partnership between nonprofit and social enterprise structures where they're working hand in hand together and they're carrying those out. In other instances, conversions make sense as well, right? If you find that there's more of a need or there's activities that are not exempt in nature, that maybe this acquisition of a social enterprise, this acquisition to carry out this need under a social enterprise structure makes more sense, right? So that structure it's very unique to a particular organization and the needs that you're trying to serve. Next slide, please. Okay, access to resources. So additionally, in light of more specifically the pandemic and that specific change, there's been many questions about the need for organizations to access resources and the inability to access restricted funds or endowments. And I'll have clients refer to them as true endowments or quasi-endowments. And so I wanted to have a slide on here to discuss that because I think there's a lot of misunderstanding within organizations of what they can and can't access. So in talking about endowments, many times nonprofits will say, it's our rainy day fund. They're setting aside lump sums of money and they're really just trying to survive on the interest or the income that is generating. And the first question, I would ask is it a true endowment? And nonprofits are saying, we're struggling and we need the money now more than ever, but we can't access it because it's an endowment, or we can't access it because it's they're restricted funds. So the first question is it a true endowment and is there a true restriction that was placed? And that question is really who placed the restriction, right? So if it's a true endowment, then that restriction was placed on the donor. And yes, you may have limitations on how much of that you can access. But there's other endowments that are referred to or quasi-endowments where the restriction was placed on the organization, right, through its endowment policy. And the organization has said, we're going to set aside this money for a rainy day, or we're going to set it aside for a particular purpose. When that restriction is set purely by the organization and not by the donor, it doesn't mean you can't access it, right? The organization may be able to go and just by board resolution, re-access those funds and reallocate how they can be used, such as, for operating expenses when it's having a stark reduction in income from earned revenue or programmatic activities, right? So restricted funds and endowments are subject to a body of law referred to as UPMIFA, which stands for the Uniform Prudent Management of Institutional Funds Act. So this act governs fiduciaries of certain charitable assets and sets restrictions and imposes oversight on the spending of such assets. So first, I tell organizations, go back and really examine, is this a restriction that was placed by the board or is it a restriction that was placed by the donor? if by the board, evaluate what is the need, and does the need and the need to access these resources justify putting to a vote through a board resolution to reallocate how these funds can be used. If the restriction was in fact placed by the donor, it doesn't mean that that restriction can't be changed. It just must be changed by the donor. And I think now more than ever, we're finding understanding and compassion from donors of, if we're making our case to them of why we need these funds and what we're going to utilize them for, we're having true transparency. Donors are more and more likely and willing to work with organizations and reallocate or lift restrictions or change those restrictions and how they can be used. Under UPMIFA, there's restrictions or laws setting out what are prudent spending measures. And fiduciaries or board of trustees or board of directors are required to engage in prudent spending measures. So what we see a lot of times are organizations really stick to, and private foundations really stick to, a minimum of the 5% spending, which, is the IRS safe harbor. This is what we have to spend, and they don't go much higher than that. And baked into that MIFA is a presumption that anything over 7% is presumptively not prudent spending when it comes to the endowment. And I think, that scares organizations quite a bit, saying, we don't want to have to, the burden of proof is on us to prove that we were in fact prudent. We don't want to mess with that. But if now, that again, the key there is it's presumptively. So you can rebut that burden of truth. Those presumptions can be rebutted. And if now, in this time of this pandemic, isn't a time where there is a rationale and prudent spending because the organization needs it, right? We had to spend more over that 7% because we needed it to save the organization. Then when is a time that you could rebut that presumption, right? So, seeking legal counsel and really teasing it out and looking and understanding what is prudent spending and what can justify that, there may be more resources there that the organization has that they didn't realize or that they didn't think that they could touch. In addition, to go back to the very first question, under the CARES Act, there's also some provisions that were enacted that really haven't gotten too much exposure, right? So the CARES Act that Congress passed in response to COVID-19 is best known for its payroll protection program from the SBA loans and other measures of cash relief. So getting less attention are the provisions that increase the tax deductibility of donations to charities, which really provide an incentive and rebut, if you will, the disincentives imposed under the tax changes, right? So the CARES Act creates two specific changes that I wanted to bring to your attention, which really should be used as marketing platforms to all nonprofits right now. So one is the universal deduction targeted primarily at standard deduction taxpayers. So as we initially mentioned, the number of standard deduction taxpayers has gone down astronomically, right? Because many taxpayers don't have more than $12,200 in itemized expenses to justify not electing the standard deduction. So the universal deduction, which is targeted primarily at those individuals, and is meant to incentivize the remaining high income givers and corporations to give. So under the universal deduction for donations, the act, under the CARES Act, it allows individuals to deduct donations to charity of up to $300 on their 2020 federal tax return, even though they take the standard deduction. So this is a change. Typically, when you're taking the standard deduction, it doesn't matter. You're not breaking out individual donations that you gave to charity, right? So there's less of an incentive. Here, even if you take the standard deduction, there's an incentive to give up to $300 for individuals, and $600 for married filing jointly. And this is an above the line deduction of up to, again, $300 for individuals and $600 for married filers. The next change was raising the charitable giving deduction cap. So traditionally, under the existing tax code, for donors who are able to itemize their deductions and therefore, commonly write direct gifts or give direct contributions to donors, the current deduction cap for 501c3 public charities is 60% of their adjusted gross income, and corporations are able to deduct up to 10% of their taxable income. The CARES Act lifts these caps to 100% for individuals and joint filers for the 2020 tax period, while corporations get to see their cap lifted to 25% for the 2020 tax period. So these are truly substantial changes to the tax treatment to donors and gives way more of an incentive to give. So for individuals, it could theoretically mean that they have zero taxable income if someone is giving big. So for example, if the taxpayer has an adjusted gross income of, let's say, $275,000, he would normally be able to deduct up to $205,000 of gifts to a charity. And then with the temporary change in the CARES Act, he could now deduct that entire $275,000, right? If he gives it all to charity in 2020. So many individuals don't know this, right? So from an individual donor perspective, it's going to make them feel more warm and fuzzy. You can go give it to the tax man, or you could give it to a charity, so it's going right back into the community to make a difference. So that should be really publicized and marketed by nonprofits to their donor bases, because a lot of donors don't know about it, right? Okay, so there's a question here. Will there be a line or schedule for this on the 2020 1040? I wish I knew, right? The 2020 1040 has not, is not released yet, so I don't know. That being said, even if it is, by the time it's released, probably not, it'll probably be too late, right? We only have so much time left in 2020, a couple months left in 2020. So, by the time they're looking, individual donors are looking at the 1040, it's, March or April of 2021. So really the onus is on nonprofits in the sector to really inform their donor bases of this benefit under the CARES Act. Next slide, please. Okay, so employment considerations. I want to touch, and we'll speed through. I always run out of time on these. But I wanted to touch a slide quickly on employment considerations because they come up so much. So we're seeing traditional businesses as well as nonprofits with their volunteer base, their staff, having to navigate return to work plans, as well as, really just overhauling and changing. Do we move our workforce completely remotely? So with that, there's many things that you want to consider from an employment law standpoint. If you are going to have your workforce go back into the office, make sure before you do that, you have a very comprehensive return to work plans, right? Your staff is really nervous. There's a lot of changes right now. And with nervousness and uncertainty, you could lose staff members because they don't want to come back because they don't feel safe. And you can have disgruntled employees because they feel as if you're not taking it seriously. So coming up with a comprehensive return to work plan of what to expect, how are you keeping your staff, your volunteers, members of the public safe when you reopen is really important. And explaining that to your workforce, right? So whether that's checking temperatures when they come in, asking that list of questions, requiring masks in common work areas, laying out your workspace to make sure they're 6 feet apart, whatever that may be, put it in a return to work plan. Many times with that return to work policy or plan, there are requirements of different safe reopening plans that are required by the state and different local ordinances that you must post on your workplace or file with the state. So it's important that you're, seeking legal counsel. You're doing the research online to make sure that you're, crossing your T's, dotting your I's. One important point to note with employment law considerations, specifically with regard to workers' compensation, is there was a big change. There's now a presumption of employer liability if a covered worker contracts COVID-19. So prior to the pandemic, Governor Newsom, and this was a Governor Newsom change, prior to the pandemic, the burden of proof was on the employee if there was a workplace injury to show that the injury was caused at work. That has completely shifted. So now the burden of proof is on the employer to prove that the employee did not contract COVID-19 at work, which is a really high burden. The only way really you're going to be able to rebut that is if they weren't coming into work, right? So they were teleworking, they never came into the workplace, so they could not have contracted it by the employer, by the nonprofit. So, something to think about. Feasibility of teleworking. If you are employing teleworking for all of your staff, do they have the equipment they need? Do they have the technology? Are we reimbursing our staff for that? And changes and restrictions imposed under CARES Act, making sure that you understand those changes, what additional sick days for them and their loved ones that they're afforded in the event that they are, contracting or suffering from a COVID-19 contraction. Next slide, please. Contract considerations. So this is a really big one. I'm seeing a lot of nonprofits that are faced with having to cancel events, whether it's donor or fundraising events or conferences. And many times those events or programs with third-party vendors, their programs have contracts involved that are forcing them into breach. So as we're rebuilding our programs, it's important that we're understanding in that resilience phase that we're negotiating those contracts to make sure we account for these. So one of the big provisions that's really important is the force majeure clause. So the force majeure clause is really important. It's a common clause that's really kind of tucked in those boilerplate provisions at the end of a contract. And it essentially frees both parties from liability or obligation when an extraordinary event or circumstance beyond either party's control occurs. Many times, those types of events are things like, war or strike, riot, crime. There's very few of them where I see disease or pandemics, right? You don't see that in all of the force majeure boilerplate language. So there's, it's an interesting issue for legal practitioners of whether or not this pandemic is deemed a triggering event for a force majeure clause, thereby not creating liability or, being able to declare a breach of another party if they're unable to act because of the pandemic. So, we're in this for the long haul. I think it's not new to anyone to say that there will be a new reality. Make sure we're accounting for these types of crises in, such as pandemics, communicable diseases in our force majeure clauses. Insurance provisions. Insurance is really expensive to get right now, as many of you probably have seen. To try to obtain employment practices liability insurance is very, very difficult because there's just such a higher number of employment related actions being brought, whether it's because, the unemployment is going up and there's layoffs, or because there's uncertainty in the workplace with forcing workers to come back into the workplace. So insurance, making sure that if you're contracting with a third party or a vendor, you have those insurance provisions to make sure that you can indemnify or push off that liability if your vendor is the one creating liability. And what riders do you want them to have? Do they have a rider for communicable diseases, which is a rider? Do they have volunteer rider provisions? Limited liability provisions. If you're going to try to disclaim liability, saying, if you contract COVID-19 while your child is playing, in this soccer, it's only going to be upheld in court if you clearly and accurately disclose all potential liabilities to that individual so that they had knowledge of what risk they were assuming. So you want to make sure that, they're very well drafted and very holistic and very straightforward, so that they will be upheld. And then your termination provisions, right? Especially for things like services that your nonprofit might be providing. There's a lot of uncertainty. We don't know, if the country has to shut down again, or the shelter in place, or you're forced to, not be able to provide a service or a good which is outside of your control. You can have those outs, and all of that should be baked into the termination provisions. Next slide, please. So programs involving public and third parties. So a lot of this are the same points as the contract provisions, but what types of contracts or other legal considerations do you want to consider if you're rolling out these new types of programs? You might need to have liability waivers and assumptions of risks that had different types of risks that were, non-traditionally not usually disclosed in these types of documents. You might be having to retain different types of riders, insurance riders, that you didn't need for your programs before, because again, the exposures to liability are inherently different. If you're changing your programs to virtual programs, you may have other legal obstacles that you have to overcome. So that maybe you're creating new intellectual property because you're building new platforms. You have new privacy law considerations. Are you collecting information, private information, from end users? Are they having to access your website? Do you have a terms and conditions of use? How are you saving and storing that private information, credit card information, donor names, donor addresses? Are they consenting to how you're storing that information? Different technology considerations. How are the members of the public or our constituents able to access these virtual platforms? Is it still as lucrative if they still don't have the capabilities to access them? And then evaluation of your existing agreements for earned revenue to, again, account for those force majeure clauses. Next slide, please. Something to note on that, the court systems now are completely clogged up. And so it's something to think about, and the delay, the money and the delay and the time that you're going to have in the event that you're faced with a breach of contract. Or there is liability. So if you're going to claim breach of contract, is it worth it, right? How long is it going to take for you to be heard, to be made whole again in the court system? And an understanding that there's quite a bit of deference being given to COVID-19 and public safety defenses and those rationales. There's many changes that there are not in-person appearances, or much, much less, depending on the jurisdiction, for appearances as well as depositions. So there may be altered effectiveness resulting for virtual appearances. So from a litigation strategy, how are we evaluating these different changes and how we want to proceed, instead of sinking money into additional and increased legal costs for litigating something? What is the value of the reward? Next slide, please. So corporate changes and modifications, I just bring this slide, we'll note on it very quickly. Again, mergers, acquisitions are winding up in dissolution, in evaluating, in these changes and having to adapt. If there is a reduction in demand, or if the cost of carrying out programs are unduly burdensome, it's oftentimes we see these pop-up of new organizations where they're doing the same thing. So they're not solving a new need, or they're not solving a new program. When if you consolidated your resources and consolidated what you're doing, maybe merging with another organization that did it, you could pool your resources to have a greater reach and a greater effect. So, in evaluating whether you're having a reduction in access to resources, what are your options? It doesn't always have to be to shut your door, right? Could it be, are we engaging in duplicative efforts? Can we consolidate overhead? Is there a collaboration with a social enterprise or another nonprofit that's doing the same thing, that it makes sense for us to pool together and engage in a merger? Or we have valuable assets. Should there be a transfer of assets and an acquisition where we're carrying out this mission through one entity instead of two? Next slide, please. So on this last slide, I'll just note, we could talk about this topic for hours, an 8-hour presentation, and I'm sure that there's many questions. This law is ever changing, and you're having to adapt on a daily basis. We do maintain COVID-19 response page on our website that gives real-time updates on all of the changes in law. I know that we went through this very quickly today. So if you have questions specifically about any of the changes in the CARES Act or the benefits for your individual donors, or you have some of those employment law questions with regard to, what are the new laws or rules with regard to paid sick time or unpaid time off in the event that an employee contracts COVID-19. What are some of the changes under the tax code? Visit our website, and there's likely a blog there that can answer your question. Alternatively, feel free to give us a call, and we'd be happy to assist in navigating this time with your organization. Thank you very much. I hope you enjoy the rest of the Academy, and I look forward to hearing from each of you. Thank you. If there's any questions, we only have a couple seconds left, but please feel free to email me your questions as well, and I'd be happy to answer them.